Hello, everyone. Welcome to the 38th forum we've had. I don't know the number yet, but it's getting up there. I am Pete Davis, the chair of the Harvard Law Forum, the longest-running American law school speaker series. It's very exciting. We've hosted JFK, Jimmy Carter, Vince McMahon, which I just uploaded to the forum archive, which we're slowly uploading onto YouTube, Dr. Ruth, Siskel and Ebert, Malcolm X, Martin Luther King, Eleanor Roosevelt, and today we have Jesse Eisinger joining them, joining this motley crew. One of my favorite ways to describe the folly of the sunny corporatists who manage most elite institutions is that they believe that there are many victims in society, but that there are no victimizers. To them, an economic system that leaves 1 in 5 of our neighbors' children in poverty is natural or necessary. To them, the radicalized climate disruption of our extractive industries is an unfortunate byproduct of good-natured systems. To them, the foreclosure crisis that has devastated black communities in our country was simply unforeseen. To them, the answer, heard in graduation speeches and TED Talks, is for everyone to come together and find a way to solve these problems without anybody making any sacrifices, without any powerful profiteer significantly changing the way that they do things. Perhaps a new app can solve the problem they propose. What I like about Jesse Eisinger is that he refuses to buy the myth that there are no victimizers, that there are no people who need to be held accountable for their actions that contributed to these structural crises. By held accountable, I don't mean it in the strictly punitive sense. We don't want to grow the carceral system any more than it already shamefully has grown. But I mean it in a simple crime prevention sense. We need a system of ensuring public safety, not just from those who steal with a gun, but also from those who steal with an Excel spreadsheet. There's a phrase for this: law and order. I invited the law school Republicans to come join us as co-sponsors today, but they didn't respond to many of their national leaders, and frankly, shamefully, to too many of Democratic leaders as well. Law and order only applies to Main Street. Well, one of the most lawless streets in America, Wall Street, is left without enough cops on the beat. Jesse Eisinger is the leading expert on those cops in our country. He is a Pulitzer Prize-winning senior investigative reporter for ProPublica. He is the author of and this is the first time in the Harvard Law Forum history, Chickenshit Club, Why the Justice Department Fails to Prosecute Executives, a widely praised book that takes its name from what insiders call the group of prosecutors, quote, who were too scared of failure and too daunted by legal impediments to do their jobs well. Here to share with the Harvard Law community the real story of the legal response to the financial crisis, Jesse Eisinger. Let's hear it for him.
Thank you so much. That was an awesome introduction. I don't know if I can top that. I should probably just leave. I was a little worried about coming to the talk to students anyway from such an august institution, because I thought that, professors are easier to snow than students. You guys probably are closer to the actual thing that's happening and won't be able to bullshit you as much. But let me call this up. I do like that you guys are receiving my book with such a title. The title is very controversial in my household because I have 2 young daughters, 9 and 5, and so two of the people in my household love the title, which means that my wife does not. We were at a dinner party a few months ago with some friends, and we sort of ushered the children off into the backyard. Very rare thing in New York, not our backyard, and suddenly we heard some chanting from the students. I mean, the kids. They are students, but they're young students. Chanting, and they divided it up to one side of the backyard and the other, and one side was saying, "You say chicken, we say shit, chicken, shit, chicken." And my wife sort of put her head in her hands. I don't think we'll ever be invited back, which is too bad because it was such a nice backyard. But anyway, thank you so much for having me to talk about the book. And what I'll do is I'll kind of run through a quick and dirty, or not so quick, not so dirty thesis, and then open it up to questions, because I think that probably that will be the best way to kind of address the things that you were curious about. But so where did I get the title, and why was Simon & Schuster so not eager, but grudgingly willing, generously willing to use it? Well, it comes from a speech from a guy named Jim Comey. Maybe that name rings a bell. The guy who was fired by Donald Trump as FBI director, but in 2002 he became the Southern District of New York's U.S. Attorney for the Southern District. And the Southern District, as many of you know, well, how many of you are Harvard Law students or law students? The majority, yeah. And is anyone going to become a U.S. Attorney at the DOJ or at AUSA? Or no, my God, I had you all pegged wrong. All right, well, you're a who's going to go into private law, corporate law, big law? You don't have to be embarrassed. You'll be embarrassed at the end of the speech, but not at the beginning. So not many. And so most of you aspire to do something else, public interest law, something like that. Very good. It's nice to be with such idealist young souls before your souls are crushed. Very exciting. So Comey comes in, and if you've been following him over the last year, you know that he likes to hear himself talk. And he decides to give the criminal prosecutors a speech. And these guys these prosecutors in the Southern District think of themselves as the best trial lawyers in the country. These guys have gone to the best high schools to get to the best colleges, to get to the best law schools, to have the best clerkships, to go to this job. And this is the most prestigious office of the DOJ. And they are the best trial lawyers in the country. You just have to ask them, and they'll verify that. And so Comey looks around the room, and he says, "How many of you have never lost a trial?" And a bunch of hands shoot up because they're so proud of their record. They think of themselves as so great, such hot shots. And he says, "Oh, me and my buddies have a name for you guys. You're the Chickenshit Club." And hands go down. These guys slump in their chairs for the first time maybe since third grade. So they're listening. What does he mean by that? Well, so what he goes on to explain is that your job is not about winning as a prosecutor. Your job is not about compiling an undefeated record. Your job is about doing justice. And justice requires taking on ambitious cases, not being afraid of losing, not avoiding losses by beating up on the easy targets, taking on the low-hanging fruit. You must take on and address the biggest, most important wrongdoing and wrongdoers in American society. And my argument in the book is that over the next 15 years, the Department of Justice writ large becomes the Chickenshit Club. What I mean by that is we do not prosecute top corporate executives from the largest companies in the country, in the world, anymore. We do not prosecute CEOs, CFOs, chief operating officers, chairmen and women of the board. These people we don't do it anymore. There's a failure. So let me sort of walk through a little bit of the history here to locate people and then explain sort of what happened. So, we have had a series in the 20th century of kind of booms, busts, and crackdowns. After 1929, we kind of invent white-collar crime. White-collar crime has to be invented. So, obviously things like embezzlement always existed as a concept, but there were a lot of activities that were exposed after the 29 crash that that were simply not criminal, and we had no way of regulating and enforcing this. So we create the Securities and Exchange Commission. We have the 1933 Act, the 1934 Act. Eventually, we have the 1940 Investment Act, and that's a process of defining and codifying what white-collar crime is. The CEO from one of the biggest banks in America shorted his own stock into the crash, knowing that it was coming. That wasn't illegal. So we had to kind of have this kind of codifying sort of exercise. Very successful. Then, skip forward a little bit. White-collar crime there isn't much prosecution for several decades, but in the S&L crisis in the late 1980s, we prosecuted over 1,000 individual executives. Many of the top executives from the biggest institutions involved in that crisis. Around the same era, we have the junk bond boom and bust, and we prosecuted arguably the most powerful person on Wall Street at the time, Michael Milken. But not just Milken. We hauled out a Goldman Sachs trader partner in handcuffs. This is, the Department of Justice, not me, when I say we. They prosecuted partners at major law firms, kind of sweeping, systemic kind of prosecutorial effort. And then in the wake of the accounting fraud pandemic of the late 1990s, early 2000s, the government prosecuted almost all the top executives from almost all the companies that were involved in that: Enron, WorldCom, Global Crossing, Adelphia, Tyco, the list goes on and on. Very successful era of prosecutions. This has never been a golden age where the rich and powerful needed to fear for their liberty if they committed crime, but there were silver ages. And then we went into a dark period from which we've yet to emerge. And my book is focused on the aftermath of the financial crisis in 2008, where we prosecuted no top bankers from any institution. We prosecuted one mid-level banker from Credit Suisse for crimes related to the financial crisis up in the Southern District. So nobody from Countrywide, nobody from Washington Mutual, nobody from Merrill, nobody from Goldman, nobody from Lehman, nobody from Bear Stearns, nobody from Citigroup, nobody from nobody. That's sort of what I focus on, but I'll give you some of the big picture statistics, which is that the Department of Justice does a really terrible job of keeping statistics, but by their own statistics, so they really haven't tracked white-collar crime much. They only started in the early 1990s. By their own statistics, in the 90s, early 90s, their white-collar cases made up 1 in 5 cases. Today, it's 1 in 10. So there's been a collapse in that. In 2016, we don't have 2017 numbers yet, it was the lowest number of white-collar cases against individuals in 20 years, down 40% from 96. Corporate convictions, convicting a corporation, was down 29% in 2014 from 2004. And that sort of overstates things because most of the companies that get convicted, get charged and convicted, are inconsequential, small companies, not big companies. So what has replaced prosecuting individuals who are committing corporate crime and convicting corporations? Well, settlements for money. Now, the prosecutors don't call them settlements. They call them things like, there's a wide variety of terms for them. Deferred prosecution agreement, DPAs, is the most common. They have non-prosecution agreements. In recent years, they've occasionally sought guilty pleas from subsidiaries or even from the parent company. These are settlements settlements except for the name. It's a kind of semantic game because they don't carry any consequences. Since 2001, in the first decade of the existence of the DPA, which is created in the Southern District in the 1990s, they do 18 of these. And then from 2001 on, they do over 420 of these. So this is the way we prosecute corporate crime from large companies in America today. We have them pay checks to settle, and they make a series of promises when they do that. And I'll get into exactly how valuable those promises are. But so corporate power is at a zenith in America today. Executives are getting paid more than ever. Corporate profits are at a high. Corporations exert more political power than they may have since the Gilded Age. But what I argue in the book is that when we're talking about inequality in American society, we often talk about wealth or income inequality. But I think the greatest perquisite of being wealthy in America today is an impunity to commit crimes. And we talk a lot about excess punishment and mass incarceration, especially for nonviolent offenders, especially for the poor and people of color disproportionately. This is the flip side, where we have a class of people who have impunity. And I believe that this threatens American democracy. It threatens the basic fairness of our society. So what happened? How did this come about? There's some kind of mundane answers that we've had a resource shift. The FBI, which investigates most of these cases and then gives them to prosecutors. After 9/11, they shifted a huge number of resources and transformed the institution to become a kind of international investigative intelligence operation. They moved a lot of moved away from white-collar investigative capacity. There were a series of losses at the DOJ over the decade. One that you guys may remember was very early prosecution in the wake of the financial crisis in the Brooklyn U.S. Attorney's Office of some Bear Stearns executives. They lost that at trial. Those losses had a kind of cascading effect, and I'll get into a little bit more detail about that. In the wake of the heart of my book is that in the wake of the successful round of prosecutions for the Enron WorldCom era frauds, there was a backlash led by the defense bar and corporations who had argued that prosecutors had been cowboys and criminalized routine business decisions, aggressive business decisions, and that was very effective. There's been, over that decade, in conjunction with this backlash, a loss of prosecutorial tools, thanks both to kind of adverse rulings from the courts and a lot of political pressure. And I'll get into those. And then the other thing more recently is there's been a kind of professionalization, corporatization of the Department of Justice. And I think that led to a defense bar mentality and diminished a kind of prosecutorial ethos and mentality. So I want to talk a little bit about the seminal prosecution that really set off this kind of cascading effects, which is the prosecution of Arthur Andersen, the accounting firm. And what happened after Enron collapsed is that the Bush era, George W. Bush era Justice Department created the Enron task force. They created a corporate fraud task force because there were a series of frauds that had been exposed, not yet WorldCom, but Adelphia, Sunbeam. There'd been a kind of corporate fraud, accounting fraud pandemic, and then Enron collapsed, and the Bush White House created, and this is why I'm sorry that the college Republicans are not here, because if they read my book, they'll see that there were law and order Republicans who truly believed in an ethos of prosecuting white-collar criminals. And one of the heroes of the book is a guy named Larry Thompson, who was a deputy attorney general under George W. Bush, under John Ashcroft, African-American guy who grew up in segregated Missouri, becomes a Goldwater Republican, and truly believes in preserving capitalism by prosecuting bad capitalists, and truly believes that crime in the suites, to use a kind of Ralph Nader phrase, is just as worthy of prosecution as crime in the streets. And he really lives and breathes it, and helps to create the Enron Task Force. The Enron Task Force is a bunch of prosecutors drawn from all over the country, and essentially, not literally but figuratively, although it felt literal, locked in a room to focus on the Enron case. And they eventually prosecute all the top executives from Enron. But the first thing they do is prosecute the firm, Arthur Andersen, the accounting firm. And Arthur Andersen was a serial abettor of accounting fraudsters. They had, all the accounting firms were in a very bad way in the late 1990s, enabling fraudsters, and Arthur Andersen was the worst. And they had done a series of companies that are mainly forgotten to history, but were very important when I was a young reporter coming up. Boston Chicken, Sunbeam, Waste Management, Quest. They had, Arthur Andersen was the accounting firm for all these firms, and overseeing the books. Baptist Foundation America was the biggest nonprofit accounting fraud of the era, also an Andersen client. And they were also Enron's client, and much deeply embedded and meshed in Enron's operations. Dozens and dozens of executives went back and forth from Andersen to Enron. And Enron, when Enron was subpoenaed by the SEC right before its collapse, Andersen had not been, and the lawyer, head lawyer, sent out a very famous email that said, everybody should review our document retention policy. Everybody understood what that meant, and they literally destroyed tons and tons of documents related to the Enron audit on that in the subsequent couple of days. 2,380 pounds of documents compared with an average of about 80 pounds a day. Shredding took place in multiple cities, having to do with Enron and who the hell knows what else. Never was retrieved. So the Department of Justice, the Enron Task Force, negotiates for a long time with Andersen. They want to come to some kind of settlement and move on to the prosecutions of the individual executives at Enron. Andersen is putting up a huge fight, very obstreperous. They're back and forth, and then the one condition that the Department of Justice says is you've got to admit that you did something wrong. They have a guy who pleads guilty, and as you know, an executive pleads guilty, and as you know, they can prosecute the company if even just one executive has committed a crime in the course of his or her work, his or her employment at the company, thanks to a 1909 Supreme Court decision, and they will not admit wrongdoing. They say that is our red line. They dare the prosecutors to take him to trial. The prosecutors feel like they can't have their bluff called like this and walk away, and so they bring them to trial. They win at trial. Arthur Andersen subsequently goes out of business. In 2005, a lawyer says this about the Andersen prosecution. The Justice Department came under a lot of criticism for indicting Arthur Andersen and putting it out of business. That was justified criticism. What has happened is that since Arthur Andersen, the Justice Department, to its credit, has focused on the awesome collateral consequences of moving against an entire entity criminally. The stigma of that, the reputational hit of that, is too severe for most companies to survive. And so they have turned to what they consider to be a lesser sanction with lesser collateral consequences. Well, first I'm going to back up and explain what is collateral consequences. Well, collateral consequences come in two forms. In the Arthur Andersen form, it was the tens of thousands of employees who were innocent, and there were innocent employees of Arthur Andersen, I assume, not innocent of all sins, but they weren't actively shredding documents, and they lost their jobs. A great pity. Sometimes in prosecutorial work, there are collateral consequences to your action. The second thing that became very famous in the wake of the financial crisis, which everybody in this room has heard, is the too big to fail problem. The idea that if you prosecute an interconnected entity, particularly a large financial institution or bank, that you will cause a cascading effect in the capital markets, a crash of the stock market, inability for businesses to secure loans, that it's too great. So who was criticizing this Arthur Andersen decision? That was Mary Jo White. Mary Jo White was the U.S. attorney in the Southern District before Jim Comey. Then she became a defense lawyer at Debevoise and Plimpton. Then after that, if anybody recalls, she was the head of the SEC under Barack Obama, a Democrat. Then she's just gone back to Debevoise and Plimpton to become a defense attorney, again, for corporations. So the Arthur Andersen case, this enabling firm, this wholly corrupt firm that had done something that was entirely unjustified and refused to admit any wrongdoing, that became a victim. That became a symbol of excess prosecution. What happens is the prosecution is overturned by the Supreme Court under what I consider to be a technicality about a judge's instructions to the jury. I don't think that would have mattered, but it is absorbed by Republicans and Democrats, defense lawyers and prosecutors, people at the DOJ, like Lanny Brewer, heads up the criminal division under Obama, and Mary Jo White, who's the head of the SEC, that this was a terrible mistake, an excess. And the reason they had, the reason that becomes a kind of accepted wisdom is that there was a remarkable PR campaign that emerged victorious that I try to detail in the book, where they take this terrible set of facts about enabling accounting fraud and shifted the conversation to the innocent employees who were losing their jobs. And they marshal an extremely effective effort, and they change the conversation, and they win. So the Department of Justice takes, not officially, but effectively, takes prosecuting a large corporation off the table. So they will not do that anymore. So what happens instead is they settle with corporations for money, as I said. They reach DPAs. So how do the DPAs work? Well, the way they work is that we have, and this is a dirty little secret of corporate law enforcement in this country, although I think anybody who has had any summer internships or associateships at a law firm will know this. We outsource and privatize corporate law enforcement to the corporations themselves. Corporations investigate themselves in America. Prosecutors don't really do it. And what they do is they hire law firms to do this. And I liken this to trying to figure out whether Pablo Escobar is running a drug cartel and asking, Mr. Escobar, could you investigate the question of whether you lead a drug cartel? And he hires the largest firm in Medellin to investigate the question. I don't think they're going to come up with the answer, the right answer. These internal investigations are incredibly professional, and they have enormous number of resources put to them. Many associate hours. I hate to warn you about this. You are going to be devoted to internal investigations. It is not glamorous work. It is incredibly lucrative work for big law. The margins on this are wonderful. One of the wonderful things for a law firm about this kind of work is that you go to the client and you say, we'd like to interview X, Y, and Z. we're never going to have to tell the government, because of a series of fights that I detail in the book and throughout the 2000s, exactly who we have interviewed. We're not going to have to produce that. That's all going to be privileged. But if you say, no, we can't interview anyone, we're going to have, and the prosecutors ask us, were you impeded in any conversation? Were you impeded in any request that you made? We're going to have to tell them yes. And the client says, here, how blank would you like the check? Because we can make it in very, very blank. And we'll just write down the number. So that's the way Big Law investigates these firms. And then what they do is they produce these reports for prosecutors and hand them to the prosecutors. And the prosecutors believe that they cannot adequately investigate corporations on their own. I don't think that that is a belief that is true, but it is ingrained. They also say to a person that this is not the way they do things, that they don't receive these unquestioningly. At least in public they don't say this. If you have a few drinks with them, they will concede this, which is essentially, my book was, the bar bills for my book were very high because of this. And what they say is that the investigations are starting points, but they're not. And if you look at data from Brandon Garrett at the University of Virginia, who's done great work on this, you find that DPAs almost always say that they should be, that the companies pledge full cooperation with any ongoing investigation as a part of the settlement, part of the agreement, but most DPAs do not actually prosecute any individuals. Most DPAs don't have any follow-on prosecutions of individuals. And there's been a slight change about this because of a memo from the Deputy Attorney General, Sally Yates, under Loretta Lynch, the last DAG under Obama, who said that we need to prosecute individuals. I don't think that's been very successful. What it has really meant is that the individual is prosecuted as a kind of low-level schmuck. So what they don't do, prosecutors don't do in the corporate law context, which they do in almost every other context, is 5 a.m. door knocking. This is prosecutors and FBI agents. They'll do that to a hedge fund manager from a small hedge fund on the lawn in front of his wife and kids. They don't do that to corporate executives. They don't have grand jury showdowns with chief executives. Southern District puts almost no top executives in front of the grand jury. And there are entirely legitimate reasons to do this. One is they need to share information with the SEC and they can't in the grand jury context. Another is that they're very worried that they'll get locked into someone saying something that they then have to deal with on the witness stand. But there's nothing like a grand jury to shake the truth out. And it's a tool that I believe should be used with sometimes. They used to use grand juries much more than they do. So instead what they do is carefully negotiated settlements with corporations. And I mentioned that the privilege fights, and I'll sort of go through very briefly. So what happened was, it used to be that prosecutors could say, if you want to enter into negotiations with us over a potential settlement, you have to cooperate. And as a measure of cooperation, you may have to waive your attorney-client privilege. And this was codified in a memo by Eric Holder when he was DAG under Reno, and then it was expanded slightly by Larry Thompson. It became known as the Thompson Memo in the wake of the Andersen prosecution. And then this was the subject of a heated, bitter, almost entirely under the radar lobbying campaign throughout the 2000s to roll it back. It was enormously successful by corporations in the defense bar, crying, howling about the sacred nature of attorney-client privilege. so much so that the Department of Justice rolled back its policies out of fear that the legislature, the Congress, is going to pass laws prohibiting them from doing this and reining them in otherwise. And so now they don't do it. And what that means is they get a series of facts delivered by the big law firm on behalf of its corporate client, but they get very little access to the raw data, the raw materials. So these investigations look very serious and professional, but they are woefully inadequate to sort of getting at the answers. And the big problem is they are studiously incurious about culpability at the top. They do not finger the board members or the CEO. And the reason they don't do that is the big law firms want to preserve their clients. So first you have to know who's negotiating these settlements on behalf of the government, and for that I'm sort of explain a little bit about who federal prosecutors are, and I'm glad that very few of you are going to be federal prosecutors, because this is the insulting portion of the talk. I don't really mean that, but as I said, federal prosecutors are the people who have performed the very best from the youngest. We are an achievement society. The people who don't achieve things go into journalism, and the achievers go into law. These are, they've gone to the best schools, as I said, and the most important salient point about prosecutors is not only are most of them young, but most of them are going to be future partners at corporate defense firms. A huge portion of prosecutors then go on not to public interest law, not to become academics, not to be public servants in any way, but to become partners at defense firms. They don't even go to plaintiffs' firms. That's kind of seen as a little bit greasy. And so, these people have had to do prodigious amounts of work from an early age. They've had goal-oriented youths. They have a drive to succeed. And the thing that they've figured out is what society is demanding of you and how to fulfill that, how to please mentors, and how to identify what their parents and teachers and institutions that they belong to and aspire to demand of them. That makes those people lousy prosecutors. Prosecutors cannot be pleasers. They have to be displeasers. They have to seek actively to deprive people of their liberty. So this is not these diligent and conscientious and well-meaning and awesomely intelligent people lack one piss-off gene that they need. And that's the thing that would make a good prosecutor. So why has there been a shift away from individual prosecutions? Well, if you understand the mentality of these people, then you understand that it takes enormous risk to prosecute an individual who is very well-heeled and well-defended. So to prosecute in a complex white-collar crime, you have to understand and pierce a corporate structure. You have to investigate for years. When I was talking to a prosecutor who prosecuted a lot of insider trading cases in the Southern District, which was the kind of prosecution that we do when they say we do white-collar prosecutions, look at all the insider trading cases we did pre-Barraro will say this. And I was talking to one of these prosecutors who said, so we had wiretaps up at these hedge fund scumbags firms, and we're listening to them plot destroying evidence. We're in the room. It's so exciting. And on the one hand, I've got that case. On the other hand, I've got stacks of CDO prospectuses where I have to figure out whether there was a crime committed. It's going to take me 3 years to even know if there was a crime committed, and then the chances of me successfully prosecuting an individual based on that crime are so low. What are my incentives, my career incentives? I can rack up a trial victory at a hedge fund. Why is it more socially acceptable to go after a hedge fund? Well, there are no collateral consequences to a smaller hedge fund. The hedge fund has fewer sort of societal protections and kind of is enveloped in less societal kind of admiration. And so to the extent that they would go after individuals, it was individuals that they could pick off easily, especially because insider trading was a kind of a prosecution that they understood and they knew juries understood it. Complex corporate accounting, they're very worried about juries. One of the things that has completely eroded is trial skills. Because we do so many settlements in the corporate context and because we have so many plea bargains, prosecutors don't do trials anymore. In the early 1970s, prosecutors did, on average, about 8 trials a year. Today, they do, on average, 0.29 trials a year. So they don't go to trial. When you don't go to trial and you're going up against senior partners at defense firms who've done many, many trials, you are intimidated. You're scared. You understand that a loss will be a career-altering thing for you. You can recover, but it's going to be very difficult. And you're afraid of the trials, and you're afraid of juries. Juries seem to be a mysterious, unpredictable entity that you can't control. And so the whole process seems very scary. The more scary it is, the more you avoid trials, the worse the problem gets. And so it's a vicious cycle. And so they sit down and they negotiate with their counterparts, or excuse me, they sit down and negotiate with law firms over the settlement. So when they're negotiating, they are trying to be brilliant, obviously, and smart and tough, but ultimately they want to prove themselves to be reasonable. They don't want to be perceived as cowboys, as outliers, as difficult. They want to be seen as men and women of proportion. Why? Because they want to be seen as someone who could sit eventually not across the table, but at the right hand or the left hand of the partner. They're job interviews. And so this is a system that does not work. It is broken. And my argument in the book is that this undermines the basic fairness of our democracy. It undermines our contract and the legitimacy of our justice system, and that people know it. I mean, people don't necessarily know the contours of a DPA, but they know that no bankers were prosecuted, the average person on the street. This is the one or two things they'll know about the financial crisis. When Barack Obama tried to reform the financial system without also having a serious effort to prosecute corporations, corporate executives, that effort was undermined. So we got DoddFrank, which was a piecemeal exercise in financial reform rather than a kind of sweeping exercise. It is perceived as very weak. I think the perception of it would have been much stronger had we also prosecuted dozens and dozens of bankers, because I do think that Dodd-Frank has aspects that are worth defending. But Dodd-Frank would have been much stronger if we had also coupled it with prosecutions. Democrats had moved to a kind of sense that prosecutions were almost unseemly, like mob justice. Timothy Geithner said, we don't want to do Old Testament justice. And so the law and order Republican had disappeared, replaced by a kind of crony capitalist Republican, and Democrats were technocrats who believed in tinkering with regulation at the margins rather than prosecuting individuals and sending people to prison. And so we got an effort that nobody believed. So it not only undermined trust and faith in Obama, it completely took the legs out of Hillary Clinton when she was campaigning. Hillary Clinton, of course, gave speeches to Goldman Sachs. So when she ran on a platform of potentially breaking up the banks and calling for more prosecutions of individual executives, which she did, no one paid attention or believed it. And then when Donald Trump ran against Goldman Sachs, ran against Wall Street, and attacked Ted Cruz and Hillary Clinton as being in the pocket of it, it was an extremely potent attack. Obviously, it was an enormous con job, one of the most spectacular con jobs in American politics, because literally weeks after he got into power, he installed Goldman Sachs executives throughout the administration. But it was effective, and it was effective because I think it's arguable that because we did not have any prosecutions of individuals, it in the wake of the financial crisis, that it contributed to Donald Trump's victory. With that, I will open it up to questions. I have a list of potential solutions, but maybe we can get into that in the Q&A.
10 minutes for questions. I'm going to start you off, and then we'll open it up.
Okay.
I always like with these forum events bringing it home to Harvard Law School. Here at Harvard Law School, 4 out of 5 people go into corporate interest law. Only 1 in 5 go to anything representing not in corporate interest law firms. Our own Office of Career Services has documents that recommend to students you should go into government, then go to a law firm, then go into government that regulates their clients, and then go back to the law firm. So a lot of that culture of the job interview starts here. And so if you were sitting with our new Dean Manning, who is trying to decide his legacy of what keeping Harvard Law School relevant, what advice would you give him about what the law schools, the watchdogs of the law, can do?
Well, that's a flabbergasting job advice. It's very true. It's very good advice from a individual profit maximization point of view. So I would take that if you take that to heart, but it's totally corrupt and dispiriting. Look, I don't think that I'm trying not to blame individuals. I do blame Eric Holder in the book, and Lanny Brewer and Preet Bharara. I do try to name names and hold them accountable because I think they were responsible for this. And I'm trying to model my behavior for them. This is the way you hold individuals accountable. But I don't hold the individual prosecutors accountable. Career prosecutors as accountable because they are doing some public service. I do think that they're motivated by wanting to do good. And then when you're in New York or Washington, D.C. or San Francisco or L.A., the cost of living is extremely high, and you can't make it on a prosecutorial salary. And you want to send your kids to Horace Mann and keep up. And I don't really blame people for that. That's it's a very hard decision to voluntarily impoverish yourself. So, I wouldn't want to go into corporate law because it's fucking boring, and money isn't worth that. So go into public service law for a little while, and try to avoid it, and move to a beautiful part of the country that doesn't require god-awful amounts of money to live in a sane life. But I think that corporate law is in crisis now. It has become an even tougher place to work than it used to be. A more embittered place, a much more profit-driven place than 30 or 40 years ago. And so it's not a place to have a kind of a career where you could be a kind of legal intellectual public intellectual or guardian of the law, a lawyer, statesman. I kind of walk through the kind of history of the lawyer, statesman in the book, and why that these firms used to be run by lawyer, statesmen. Now they're run by businessmen and women. And so the firms have changed. So go in with your eyes open. Yeah.
Thanks a lot for coming. This is great. One thing I was hoping you could talk a little bit about is specifically about DPAs in terms of like actual deterrent effects. Because I mean, all your cultural comments are well taken and seem correct. But I think you mentioned Brandon Garrett, and him in his book Big to Fail talks about sort of reform. Like he talks about DPAs as problematic and reforming them. I mean, it seems to me that they may lower collateral consequences in a way that maybe we should have. We should be worried about collateral consequences in criminal law just in general. So yeah, I mean, do you think that they're just?
Well, I think that I would start by worrying a lot less about collateral consequences than they do in corporate law. I mean, I think corporate law enforcement. So yes, maybe we should worry about collateral consequences, but we have such a spectacular problem of corporate crime that the pendulum has to go the other way. So I think the DPA regime is fundamentally broken. I think you can tell that it's broken because it does not deter corporate crime. And the reason you can tell that is that we have recidivist corporations that keep entering into settlements with the government. So J.P. Morgan, Pfizer, BP, Wells Fargo, keep running into systematically running into problems and keep settling for money. So they are not fixing their broken cultures or their criminal conduct. And so the DPAs do not deter corporate crime. Even though the Department of Justice has tried to do a number of things, they set up compliance departments, they set up monitors. So I want them to get away from the DPA and use the DPA as a very last resort. Instead, I think prosecuting individual executives would have enormous deterrent effect. That one prosecution of a CEO is worth 20, 30 DPAs. And so, Pete talked about reducing our carceral state. I don't know ever how to pronounce that word. I want to throw more people in jail. I'm sorry to say. I think we're putting too many of certain people in jail and prison and not enough of another. So I would like for them to, I think that prosecutions of wealthy individuals has a deterrent effect because they are well informed about the news, so they'll see their peers going to prison. They have reputations to preserve and money. So I think that works. And I think we should experiment with it more. There are very few academic studies to prove this. It's kind of a belief. Yeah.
But did Barack Obama really try and reform the financial system? That's the fact that he was perceived by many as some kind of a progressive, made it easier for him to kind of stymie or dilute any types of reforms. And if he had been a kind of Republican, which in the popular imagination is more associated with business interests.
I think that DoddFrank was a weak reform of the financial system that has led to a modest improvement in the safety of our financial system. We created the Consumer Financial Protection Board, which was a pretty good accomplishment. I'd say A minus, B plus, and now being entirely gutted by the Trump administration and Mick Mulvaney. So I would say, yeah, the Dodd-Frank reform was a financial reform that was woefully inadequate, but not entirely useless. Yeah.
In contrast to the corporate, there are prosecutions of politicians, and the experience that I have is in Boston, which it seems to me that the prosecutors are overly aggressive, and I'm wondering how this fits into your thesis. I suppose it may be that the prosecutors are not interviewing for jobs with defense lawyers for these politicians, since most of them don't have that much money. But there is, I think, a clear dichotomy between their attitude towards the corporate and towards politicians.
I agree with that. So one of the things is I think that it's easier to prosecute politicians because they have much less, fewer resources, and they're defended by smaller firms, or the defense attorneys don't have as many resources, or not as good, so they see them as slightly easier targets. Again, I completely agree with you that there's not a revolving door issue there. The revolving door is not the only problem, but it is a problem in corporate law enforcement. The other thing is I think that there's a cultural affinity. So what I was trying to get at earlier was that I think that there's an elite affinity about corporate prosecutions, that prosecutors and regulators see Goldman Sachs bankers as, and they are, well-educated, erudite, articulate, cultured people. In fact, one of the emails I have in the book is from an SEC guy who says, when they bring a case against a Goldman Sachs banker, he says, remember, these are good people who've made one bad mistake. So they have this kind of fundamental belief that corporate executives are mostly good, and if they have done something wrong, that it could just must be a mistake, instead of thinking, well, maybe there's some systemic problem, they're making many, many more mistakes, and maybe these aren't mistakes at all, but crimes. But when they look at politicians, they see scumbags. They see, I think they perceive somebody like Shelley Silver in New York, or Dean Skelos, as a kind of two-bit greaseball who they don't feel much compunction to prosecute, and they also feel like there's an obvious violation of the political system in that kind of corruption. So it brings their kind of moral outrage in a way that manipulating a CDO and screwing over a German bank doesn't necessarily produce that kind of moral outrage.
Time for one more question?
Yeah. So you talked a little bit about the buildup of compliance departments post-DoddFrank, and whether that actually has had an impact on reducing crime. It does have an impact on the culture of the banks, such that they don't produce evidence in the same way. Like, they're told anything you put in writing could be, you would have to defend that in front of Congress. Like, chats are monitored. So given that there is less evidence being produced, how should prosecutors be dealing with that change?
That's a very good question. So what they need to approach these cases completely differently than they do now. They're very dependent on the stupid email, and people are less stupid now. Goldman Sachs bankers put in their emails LDL. That means let's discuss live. And so what they need to do is change the way they prosecute, and break their dependence on the internal investigations, and recognize that the compliance departments are internally protecting the corporations, not ferreting out wrongdoing, or to the extent that they're ferreting out wrongdoing, ferreting it out and trying to get it cleared away and dealt with in a very quiet way. So they need to investigate the way they investigate mobs, the way they investigate drug organizations, or the way Robert Mueller investigates the Trump collusion scandal, which is that they need to flip lower-level individual witnesses and work up the chain. So the way you do a mob prosecution is, and everyone knows this, but and all prosecutors know this, and this is not my original thought, but they just don't do it for a wide variety of incentives and institutional reasons. But the way you get a mob prosecution is you prosecute the soldier to get to the capo di tutti capi. It's this exact same thing to get to a CEO. And in fact, so Jeff Skilling and Ken Lay, the two top executives at Enron, they never put anything in email. There was no documents. There were no damning documents in that, and they prosecuted them anyway because they had executives who had flipped, who sat on the witness chair and said, I committed a crime, and I committed it with that guy there. So that's the way they need to go back to these. So they should do many, many fewer investigations. They should put many more resources into it, and they should have human beings.
Let's hear it for Jesse Eisinger.